Hello everyone. So today we're talking about the law of agency and athlete agents. I think there are actually a few of you who are interested in being an agent for an athlete or athletes. So basically this chapter covers the basic principles of agency law as well as specific laws regulating athlete agents. The athlete agent arena involves multiple levels of regulation including state statutes, federal statutes, private associational agreements, common law or basic agency law, and uniform laws. Now, the management context pertaining to agency with relevant laws and cases looks something like this. We'll be talking about each one of these topics today. So defining agency, basically it is a relationship between parties in which one party, the agent, agrees to act as a representative of the other party or the principal. The agency law defines how and when agency relationships are created. Agency law governs the relationships when one person hires or employs another to do his work, sell his goods, and or acquire property on his behalf. The agent typically negotiates a contract for the principal. So, what's your image of athlete agents? Do you think of high-powered famous agents who have negotiated multi-million-dollar contracts for famous clients? Do you think of Tom Cruise in the movie Jerry Maguire? There are typically three types of agency relationships. One of these is the employee and employer, which typically is the most types of agency relationships. They typically occur in that realm. With the employee or with the principal and agency, that's the pro athlete and the athlete agent. And then you also have a principal and independent contractor. So the university and a general contractor building a new stadium. Now, all contractual relationships involve a benefit to one party through the performance of another party. And the agent actually acts as the fiduciary, which is a person who acts primarily for the benefit of another. The nature of that fiduciary relationship is that one person entrusts his or her interest to another, and the agent must act loyally for the principal's benefit in all matters connected with the agency relationship. So in creating the agency relationship, it does require, number one, a manifestation by the principal or the athlete, if you will. And there must be mutual consent. Now, these agreements can be either informal or formal. So they can be oral or they can be written. But there are some basic contract principles that apply. And both parties must have legal capacity to enter into the agreement, meaning they must be 18 and over. You can't sign someone who is 17 without parental consent. And there's some authority that is important to look at in the agency relationship. So there's actual authority, which is express. Typically, that is in a formal, written, or oral agreement made between the parties. There's also implied actual authority, and this is where it's implied from the conduct of the parties. So usually if they're hanging out together, that's usually something that it's implied. It's not necessarily written, but it may be implied. There's also apparent authority. This is where a third party relies on conduct of the principal, suggesting that agent has authority. So the principal has stopped from denying agency relationship. Ratification is where no actual agency exists, but the principal accepts or ratifies the unauthorized acts of the agent. And so they're accepting the acts of that agent or nullifying the acts of that agency as well. The fiduciary is a person, again, who acts primarily for the benefit of another. The agent must act for the principal's benefit in all matters connected with the relationship, in loyalty and in good faith. Both agent and principal owe duties to the other. So it's a 50-50, or there is, I don't know if you can call it 50-50, but there is an equivocal relationship there. Trade-off, if you will. Now, as far as summary of duties, duties to the principal, of the principal to the agent, basically the agent is expecting to be compensated or reimbursed for the work that they are doing. They also are asked to have or provide safe working conditions for the agent. And then also that you are expecting some performance from that agent. So you're expecting something to happen from the negotiations that they are doing for you. Now, as far as the duties to the agent to the principal, there is expected cooperation as well as loyalty. You're putting basically your life in these people's hands, and you're expecting something good to come of it. And so you have to have a lot of loyalty, and you actually saw that in Jerry Maguire if you watched the movie, and that there was some trust that you had to have with the agent. There has to be a duty of accounting for your funds, your property, whatever you're entrusting them with, and duty of obedience, that you're going to follow their instructions. So in some ways it is a trade-off. You're asking them to do something, but they're also asking something from you, performance. So it is a relationship. Contractual liability of principal and the agent. There are classifications of the principals. Number one, it is something that it has to be disclosed. And with this, that a third party is aware of the identity of the principal and the agent is acting on behalf of the principal. There may be a classification that's unidentified. So the third party is aware that the agent is acting on the behalf of another, but doesn't necessarily know the identity of the principal, or if you will, the athlete, to put it in some context. Or undisclosed classification, where a third party is not aware that the agent is acting on the behalf of another. In this particular case, you can say something like a buyer on eBay bids on an item for a sport memorabilia auction. And basically, they're going to either resell to a third party or they are purchasing it for a specific person. Now, a principal is someone who is always liable for an agent's authorized acts. So you can't just say that your agent was acting, that you were not responsible for their acts. There is a shared responsibility there. So again, it really is about trust and communication. Now, there are some legal issues related to athletes and athlete agents. The relationship between the agent and athlete, once a relationship is created, that doesn't really even make sense, but there is a relationship there. There are interactions of agents with student athletes in an attempt to secure a relationship, and we'll talk a little bit more about that in just a bit. Some other legal issues related can be the relationships between agents and agencies when competing for clients, or when agents leave one agency for another. Now, student athletes and agents. So talking about those who need to understand the law and legal issues, and really to prepare for being an agent, oftentimes they'll recommend that you go to get a law degree, and that is definitely one way to go about it. There are other, and we'll talk more about it, certifications that you can do as well. People that need to know the law are, of course, athlete agents. You've got to negotiate contracts, and so that does require higher order of thinking and communicating. So you have to have good written and oral communication skills. University compliance officers. Oh my gosh, there are tons of information coming in every day, and they have to be able to relay that to the coaches, to the players, to the university. So they really need to know the law. Student athletes, you need to have some understanding of what is going on, so that you keep yourself out of hot water. And the same thing with professional athletes. And employees of the NCAA enforcement staff, they need to know so that they can enforce those rules, and look at who's doing well and who's not. And then contract negotiators for the professional sports team. So really, you need to have a good understanding of the law and what is going on. Again, keep yourself out of hot water and others. So an athlete agent regulation, this was an act that was created in 2000. It's the Uniform Athlete Agents Act, and 43 states adopted it. Basically, athlete agents are regulated under federal law. It was intended to regulate athlete agents and to also provide protection for student athletes. Now, it does notify educational institutions when an agency contract is signed by a student athlete. It also establishes civil and criminal penalties. Now, with that, there are some requirements for the UAAA. Number one, you have to register. And so, as an agent, one must obtain a certificate of registration from a state in order to act as an athlete agent. There also are disclosures, and the UAA requires all agency contracts to be in a recorded form and signed by the student athletes. There's notifications, and we'll talk about those in a moment, and also penalties and remedies. UAAA Act establishes civil and criminal penalties for violations of the Act, and an educational institution does have a civil remedy when it is damaged by a prohibited contact of an athlete agent or a student athlete. So, to break those down a little bit more, agent registration, the UAA requires agents to register and disclose training, experience, and education in each of the states in which they have contacted a student athlete. It also provides safe harbor for unregistered individuals with whom a student athlete initiates communication. So oftentimes, it's not necessarily the agent contacting the student, but the student contacting the agent. Or contacting someone and asking them to be their representative, and they aren't registered in that particular state. Now, with disclosure, all agency contracts must be in a recorded form and signed by the student athlete. Now, under NCAA rules, a student athlete loses his eligibility if he or she enters into an agreement with an agent, retains an agent, accepts transportation or other benefits from an agent, has ever agreed orally or in writing to be represented by an agent for the purpose of marketing his or her athletic ability or reputation in that sport. Due to possible, and really this disclosure is, you really want to prevent the possible loss of intercollegiate eligibility. And so with that, the contract must contain a warning to the student athletes and telling them, of course, that they could lose their eligibility at the university that they are going to, and they'll lose their scholarship. And also that there's a clause in there that says the student athlete can cancel the contract within 14 days, although that cancellation may not restore their eligibility with the university. So if you sign that contract, it may mean that you've lost your scholarship eligibility, and even though you may cancel the contract, it's still, you may not be able to tie that back with the university. Now, there are eligibility rules with the NCAA. The student athletes lose their eligibility if they enter into an agreement with an agent or retain an agent, if they accept transportation or other benefits, and if they agree orally or in writing to be represented by the agent for the purpose of marketing their athletic ability or reputation. Now, the notification rule, the UAA requires both the agent and the student athlete to notify the athletic director about an agency agreement within 72 hours of signing the agreement or before the next scheduled athletic event, whichever comes first. It does protect institutions from penalties resulting from allowing ineligible players to participate. Some of the penalties that could include would be loss of scholarships, prohibition from championship events, probation, or forfeiture of tournament winnings or other revenue. Some examples of prohibited conduct: an athlete agent trying to convince a student athlete to enter into a contract may not give any material, false, or misleading information, or make a false promise or representation. They may not offer anything of value to a student athlete before the student athlete enters into the agency contract. And they may not offer anything of value to any individual other than the student athlete or another registered agent. So they couldn't offer anything to their family, if you will. That would be a prohibited conduct. So assume you are your school's starting running back. How would you react if you were approached by an agent who promised perks like cash, an expensive car, and the ability to work out at an NFL's team's training camp? If only you would sign with his agency. Would you be tempted to sign? Why or why not? So SPARTA. SPARTA is the Sport Agency Responsibility and Trust Act. And like I said earlier, 43 states have adopted the UAAA as of July 2013. However, several states still have no laws regulating athlete agents. So Congress passed the SPARTA in September 2004 to supplement the requirements of the UAAA. However, it is not as comprehensive as the UAA. It does provide some protections to student athletes in states where there is no form of athlete agent regulation. Now, as far as the agent is concerned, they are expected to acquire necessary training, skills, and expertise. Their primary job is contract negotiation. So it's really important that they be an effective negotiator and that they are able to express that agency relationship. Now, there are other types of agency relationship, and one in which this agent serves as a financial consultant or as an endorsement representative. So again, on the other side of making more money, they're able to do endorsements and that sort of thing. And so you can represent the athlete as an endorsement representative. Now, as far as agents for professional players associations, there are restrictions on agents, and really this is to protect pro athletes from a breach of agency agreement, breach of fiduciary duty, or fraud. And there is a certification process that you have to go through. It really depends upon the player association as to how strenuous it is. So you have to look at each agency or player association to determine what is needed in that particular instance. As far as competitive advantage strategies with law of agency and athlete agents, you basically apply basic contract principles when establishing or dealing with agency relationships. So you're putting agreements in writing. Make sure to educate yourself and employees about legal restrictions on athletes and agents, as well as those imposed by the NCAA and other associations. One of the things that the university athletics department does is they send out once a week or once a month tips on how to keep yourself out of hot water and little scenarios that go along with that. So just trying to keep your, keep your information current and that you are communicating is really important. And then conduct seminars for your student athletes to help them understand what is permissible as well. Make sure that you put it in the handbook. So, did you know that approximately half of all athlete agents do not represent a single active player? Does that change your impression of agents? And imagine that you are the agent for a professional basketball player who is weighing two free agency options. One is for a lot of money playing for a small market team. The other's for less money playing for a larger market team where he'll get more exposure. What do you recommend and why? All right, this concludes our discussion for today. I look forward to hearing from you on the discussion board. I'll talk with you soon.